Hello, it's Phillip Taylor from Richmond Green Chambers speaking. I'm talking about a book which I think many of the newer members to the legal profession, the bar in particular, may find helpful. It's called Abuse of Process, A Practical Approach by Colin Wells. And this is actually a cover shot of it. It's a relatively slim book from the Legal Action Group. And Colin Wells and I exchanged some emails about this book because I think it's an excellent guide for people in an area of law which sometimes is a little bit misunderstood, not just by counsel but also by the judiciary. I've given the title The Staying Power of the Defence, and there's a reason for that, because clearly it's not the easiest area of law sometimes to get involved in. For instance, when I did my first abuse of process application, I wasn't actually a very happy man. The reason for that is I could hardly find in those days anything about the subject that would assist me. And obviously my instructions were sparse, to put it mildly, in this particular case. I'm not going to mention the court, but it was actually in the Midlands. The problem was the lack of proper research into abuse of process proceedings generally, because no detailed statements in our main books really were there, and it limited practitioners in terms of the information that they could find, which could only really come from Archbold, and as I say, it was relatively minimal. Obviously it wasn't very helpful on some of the other circuits where they tend to use Blackstone. But what we've got now is a much easier life, thanks to Colin Wells, aided and abetted by Rock Tansey, Queen's Counsel, and an excellent forward given by him and those involved at 25 Bedford Row. Mr. Wells has written A Practical Approach, which is the title, very much in keeping with the approach of the Legal Action Group generally, which supplements comprehensive coverage of criminal procedure with a practitioner's link to tactical guidance, which is very important here, skeleton arguments and useful reference materials which were somewhat lacking elsewhere, as I'd found to my cost. Rightly, therefore, his target audience will comprise criminal lawyers in the main, obviously police station advisors to a certain extent, the CPS, and of course HM, Revenue, Customs and so forth. Obviously litigation learners, trainees of course, will find it helpful, but I do think the judiciary will find it of use as well. And I've noticed in recent years that the legal action publications are appearing more on the books on the bench than they used to in the past. Now let's look at the problem of the courts. The criminal justice process at court level has both a general and an inherent power to stay proceedings in order to protect the process of justice from abuse, which is obviously sensible. Therefore, the aim of the system is to secure fair treatment for various people, and of course the important thing that we have to bear in mind here is making sure that there's always a balance, especially when it comes to the defendant. For instance, every day in the courts applications are being made, often providing a sound basis for subsequent appeals. And what I found most attractive about this book was the examination and the explanation of the concept of abuse of process and how it operates within the criminal justice process. It's an area which is not really covered when I was at bar school, so I had to get up to scratch with it very much after pupillage. The contents of the book are nicely logically laid out, because it's an easy to read guide with 11 chapters, although I wasn't quite sure why it needed to be split into 2 parts. However, the contents include, of course, the usual, which is the introduction to the common law, European Human Rights Court views, the Act itself, abuse of process at police stations, entrapment, unfair conduct, and a whole range of other things which you can see when you look at the book itself. It also has some useful appendices, and the one I think was very effective was the Home Office circular on cautioning of adult offenders, which has in the last decade been very much to the fore within the way in which the criminal process is delivered. You've also got, of course, the Code for Crown Prosecutors, which is, again, very useful for those of you who won't have seen what we actually do when we prosecute cases. Each chapter has a mini summary, and I like that because it's a quick, easy to read thing which basically gives you something that's invaluable because you can see it very quickly and go to what you're after if you're busy and pressured. I found that the best chapters covered disclosure in chapter 4 and unfair conduct in chapter 8. Obviously looking at double jeopardy, which has changed its basic concept in recent years. I think the book's also for editors, and there's a reason I mention that. Chapter 9, it's entitled Adverse Publicity, and it should be bedtime reading in my view for some of our national newspaper editors who really need to have a little bit of a talking to with some of the stuff they produce. Mr. Wells starts the way he means to go on when he writes and says the following. He says, media-generated notoriety can prejudice an accused, and this may lead to a jury being discharged, an indictment being stayed, or a conviction being quashed because of adverse publicity. And I can think of a number of occasions, I'm sure many other people can, where this has happened quite unnecessarily. However, don't get me wrong, I'm not trying to muzzle the press. I believe the press must uncover stories that are of general interest to the public, and I don't want them muzzled in any way. However, there's got to be a bit of a balance coming in. And with the new media, especially the internet and the issues of reputation, one has got to be careful. I think also special mention should go to the piece on North American media coverage cases, which is also here, and the guarantee in the Sixth Amendment, of course, which says trial by an impartial jury and so forth. And we obviously can remember Lord Coke's comment that a juror must be as indifferent as he stands unsworn. And it's useful, of course, to be reminded of such a point with the current suggestions that the Human Rights Act might be reinterpreted, and we're obviously moving down the road now of a green paper looking at the future of human rights and responsibilities. Anyway, as I say, we shall wait and see. This is a great book, and I'm very glad to have it. It's great as an addition to my Chambers library because it's an ever-evolving area of law which is buffeted by the political norms of the 21st century. We're going out there into some quite interesting new realms of activity on reputation, persona and so on. And we want to get the balance right. I think Mr. Wells has got it right. As I said, it is about the staying power of the defence. Thank you very much. Goodbye.